Mr. President, I rise to celebrate Women's History Month and support S.J. Res. 1, legislation I introduced with my partner in this effort, Senator Murkowski of Alaska. Our bipartisan legislation would remove the deadline for the state's ratification of the Equal Rights Amendment, the ERA, and I am pleased that the House adopted the companion version of this legislation, H.J. Res. 17, last week. I now urge the Senate to take up and pass this legislation. Ratification of the ERA would expressly prohibit discrimination on the basis of sex in the United States Constitution. The amendment simply reads, "Equality of rights under the law should not be denied or abridged by the United States or by any state on account of sex." In January 2020, Virginia became the 38th state to ratify the ERA, which was first proposed in 1972. Congress has the authority under Article 5 of the Constitution to set and change deadlines for the ratification of constitutional amendments, and has done so on numerous occasions. Recall that in 1992, the 27th Amendment of the Constitution prohibiting immediate congressional pay raises was successfully ratified after 203 years. That amendment was initially proposed as part of the original Bill of Rights in 1789. There should be no time limit on equality. Even as we celebrate America's first female vice president, our nation is held back as the only modern constitution that fails to enshrine full equality for both men and women. This is unacceptable. Most Americans are surprised to learn that the ERA is not already part of the U.S. Constitution. The states have done their job to make this happen. Now Congress must finally do its job and remove any legal obstacle to certifying the ERA. Women were indeed left out of the Constitution intentionally by our founding fathers. American women, however, did demand equality as our country was being founded. In a letter in March 1776, Abigail Adams wrote to her husband, John Adams, urging him and other members of the Continental Congress not to forget about the nation's women. The future First Lady wrote, in part, "I long to hear that you have declared an independence. And by the way, in the new code of laws, which I suppose it will be necessary for you to make, I desire that you remember the ladies and be more generous and favorable to them than your ancestors. Do not put such unlimited power in the hands of the husbands. Remember, all men would be tyrants if they could. If particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation." Sadly, the Founding Fathers did not heed Abigail Adams' call. Most notably, women were denied the right to vote for nearly 150 years. More broadly, women were treated as second-class citizens through our nation's history and were denied other basic and fundamental rights, such as being able to own property or work in their chosen occupation. Women compose a majority of the American population, but continue to be underrepresented in government, elected office, the courts, and the business world. Without the ERA in the Constitution, the statutes and case law that have produced major advances in women's rights since the middle of the last century are vulnerable to being ignored, weakened, or even reversed. Congress can amend or repeal anti-discrimination laws by a simple majority. A new administration can fail to vigorously enforce civil rights statutes. The Supreme Court can use a lower standard of intermediate scrutiny to permit certain regressive forms of sex discrimination. Indeed, even today, women do not receive equal pay for equal work. The ERA would provide a needed constitutional basis for legislation advancing women's equality. Historically, the Equal Protection of the Law Clause of the 14th Amendment has been used to fight discrimination on the basis of gender. However, without language in the Constitution specifically establishing that there shall be no denial or abridgment of rights on the basis of sex, the Supreme Court will likely continue to apply a lower level of scrutiny in cases related to discrimination against women. By contrast, the Supreme Court uses the strict scrutiny test in reviewing cases of racial and religious discrimination. As former Supreme Court Justice Anthony Scalia, a fervent originalist, once stated, Certainly, the Constitution does not require discrimination on the basis of sex. The only issue whether it prohibits it, it doesn't. Former Supreme Court Justice Ruth Bader Ginsburg stated, "Every constitution written since the end of World War II includes a provision that men and women are citizens of equal stature. Ours does not. If I could choose an amendment to add to the Constitution, it would be the Equal Rights Amendment. I would like my granddaughters, when they pick up the Constitution, to see that notion, that women and men are persons of equal stature. I'd like them to see that in the basic principle of our society." Public polling indicates that the country is ready for the ERA. Today, nearly half the states, including Maryland and Alaska, have a version of the ERA written into their state constitutions. In the era of Me Too, there have been a renewed energy for adopting the ERA, as society finally addresses the long-standing problems of violence and sexual harassment against women and demanding justice and accountability. Just a few weeks ago, we celebrated International Women's Day worldwide on March the 8th with the 2021 theme, Choose to Challenge. It is now far past the time we bring the conversation of women's equality and empowerment to center stage. The United States of America is one of the most developed, wealthiest, and admired countries in the world today. And immigrants from all over the world continue to travel to the United States to pursue their dreams and make a better life for themselves and their families. However, to this very day, the Constitution of the United States, our nation's supreme law of the land, still does not declare that men and women are of equal stature. The passage of this historic amendment would truly never be more possible or needed as it is today. Let me quote from President Biden's statement on the ERA upon the House passage of this legislation last week. "Gender equality is not only a moral issue, the full participation of women and girls across all aspects of our society is essential to our economic prosperity, our security, and the health of our democracy. This is especially critical right now as the coalition of public health crisis, the collision of public health crisis, economic crisis, and caregiving crisis have erased decades of women's economic gains and pushed more women out of American workforce than we've seen in more than 30 years. President Biden concluded, "It is long past time that we enshrine the principles of gender equality in our Constitution." Let me address one other issue regarding a recent decision on the ERA and the validity of the state ratification under the previous congressional deadlines. In this case, decided by Judge Coteras in the United States District Court for the District of Columbia, it is just as important to discuss what the judge did not hold in his decision. Notably, the judge in this case wrote, equally significant as the court's holding is what it does not hold. Congress has not tried to revive the ERA despite both deadline expirations, so the court is not confronted with that difficult issue. Lastly, the court does not express an opinion on the merits of the ERA as a matter of policy. It merely enforces a procedural time limit that Congress set when proposing the amendment. In my view, this decision makes the need for decisive congressional action clearer than ever on this procedural time limit, using the power of Congress under Article 5 of the Constitution. It is far past time for Congress to take up and pass this legislation that would remove the time limit for the ERA ratification, which will remove any remaining legal ambiguities about congressional intent. Let us take up and pass this legislation without further delay and finally write equality between men and women into our Constitution. With that, Mr. President, I would yield the floor.